Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, and thank you for stopping by. All right, guys, what we're going to talk about on this episode of the Bullet Points is something you may have heard a little bit about, but you didn't catch the most important part. There was a few videos, a few channels, a few conversations and news reports that we saw yesterday about Polymer 80 getting hit with a $4 million fine in Washington, D.C. court systems. However, that's not the big story here. Yes, that is a part of it, but it is the small part in the entire whole of the story. And this goes nationwide. This goes ATF. This goes federal. This goes states' rights. This goes everywhere. And that is what we're going to talk about right now. As always, everything is linked in the description box below. And my fellow lords and ladies, of those of you who went with the established titles, they have come back again to make more of you lords and ladies in your own right, in your own manner. So with that, I'm going to say a quick word from then, and then we're going to get into this, and I cannot wait to show you the bigger picture on this one. You guys heard of the castle doctrine? Well, with this sponsor, we're going to take it to the next level. And if you are defending your castle with something more traditional that looks like this, or maybe something a little more modern that looks like this, Established Titles gives you the ability to call yourself lord or lady while defending your castle. Now, the title packs give you 1 square foot of established land on a private estate in Edelston, Scotland, and an official certificate with a crest like you see right here. You may all refer to me now as Lord Braden. Thank you in advance. Your certificate features a unique plot number with which you can see the exact location of your land. And if you're one of the first 200 to use the link in the description box below, we can create our own little LOA kingdom near my personal plot. It makes a great last minute gift. They even have couple packs that come with adjoining plots of land in said fiefdom. They plant a tree with every order and work with global charities, one tree planted and trees to the future to support global reforestation efforts. My personal favorite reason to do this? You could officially change your name to Lord or Lady, so anything woke will have to address you by your proper title, which will send them into the next dimension, which might be worth it by itself. And you can get on that credit card, and you can even put it on your dating profiles. It makes an amazing last-minute gift. Establishment Titles is actually running a massive sale right now. Plus, if you use the code Langley, you get an additional 10% off. So go to establishedtitles.com/Langley to get your gifts now and help support the channel. And thank you so much in advance for checking it out. All right, so let's hop into this. Of course, you've got the Polymer 80 situation with the $4 million fine, but again, that's not the focal point. That is a result. That is not the most important piece, and that is what we're going to dive into. So what I'm going to show you right now is I'm going to show you the actual judge ruling from D.C. and how it ties in nationally. I'm even going to feature myself in a cameo from a video that we did earlier this week from something in Texas where a similar lawsuit was in place with a different company, also around 80%, going for the AR rule, the receiver rule from the ATF. This is incredibly important. Please watch this whole video and send this out because there's a lot to understand that this fight is much bigger than $4 million. All right, let's get it. Judge rules ghost guns are firearms and bans Polymer 80 from selling them to D.C. residents. The judgment is significant even outside Washington, amid other lawsuits against ghost gun companies and ahead of a new federal rule on them. Now, you're talking about the ATF rule about receivers and what's a gun, what's not a gun. Okay, fine. That's what we're talking about. However, this is going on nationwide. And again, I want to stress, it's not just about this Washington judge ruling, even though this is an important piece in the whole tapestry. All right? Everything is always linked in the description box below, and please check it out for yourselves to check my receipts. But here's what happened in D.C., then I'm going to tie it together. Ghost gun kits and parts are in fact firearms, a court said in a landmark judgment barring one of the nation's largest manufacturers of the homemade and untraceable weapons from selling it to do-yourself products to residents in Washington, D.C. Talking about PMFs, unfinished receivers, and you finish them yourself. That's all they're talking about, okay? But the reason that this is really crucially important is because they're trying to redefine what a firearm is from the bench. This judge is attempting to say, this is definitely firearms. These parts are definitely firearms. You can't do that, judge. And what I'm about to show you guys in a second from my video previous this week, another judge in Texas had the DOJ attorney literally say, no, it's perfectly legal to sell 80% lowers. You just can't sell a jig with them. I'm going to show you everything here, but like I said, this whole fight, since Biden has been inaugurated, it's always about going further in the system and fighting back. They're going to be on the offense. That's what they've done with this executive rule. However, you're starting to see differing rulings from different judges, which means it's going to go farther up the chain. And that's when FPC's FPC's lawsuit is going to come out and get more judgments and rulings. But let's keep going because I got some more stuff to show you. Polymer 80, a Nevada-based ghost gun manufacturer and distributor, has to pay more than $4 million in penalties for making false claims about the legality of its products. A judge on the Superior Court of the District of Columbia ruled Wednesday. So that's the that's the crux right there. You got to pay $4 million because you were marketing something legal as it was not legal. It's completely legal. According to federal law, it's completely legal. This is where you're going to get that judge system to take over, because this judge right here, I believe the last name is Scott, they are making legislation and they are legislating from the bench, from the judicial branch of the government. You cannot do that. And it's going to keep escalating up the judicial cycle. But check it out. As a result, Scott, the judge, ordered the company to permanently stop selling them to district residents and barred Polymer 80 from saying the products are legal here. Scott cited, quote, Polymer 80's alarming belief that the sale of its firearms is legal in the district as part of the reason the court granted the plaintiff's request for a permanent injunction. It's not a firearm. You can look at federal law in the Gun Control Act, the GCA of 1968. It is not a firearm. In fact, we're about to go into this in a second about how decades upon decades of precedent say it's not a firearm. But the judge is trying to rewrite law from the bench. And this is important because when I get to the Texas part, you're going to see a big conflict in 1 second. More significantly, Pacino said, this is the guy from Giffords.org, the judgment validates an upcoming Bureau of Alcohol, Tobacco, Firearms, and Explosives rule that will subject ghost guns to the same regulations as traditional firearms, even though they're not firearms. Beginning August 24, those who sell ghost guns will have to be licensed. Background checks will have to be conducted before sales, and manufacturers must ensure the parts have serial numbers. Quote, the court is already recognizing what the ATF is recognizing, Pacino said. Again, gun controller. But now I'm going to take you to clips of what was occurring in a Texas court against the exact same ruling, a lawsuit brought by a different Polymer 80 company. Check this out, and you'll start to see inconsistencies and why it's going to go bigger. And this is the important piece. For decades, these companies enjoyed a status quo of no government interference because under the Gun Control Act of 1968, the feds did not define firearm frames, also known as lower receivers and receiver blanks, as firearms subject to regulation. Keep that in mind. Lower receivers and receiver blanks. It's coming from this a quote, okay? That's going to come back in 1 second. All right. So other than the obvious of me quoting myself here, which was kind of funny, you're going into a Gun Control Act of 1968. You cannot redefine it without Congress legislating it. We're starting to get into that area where West Virginia versus EPA, the Supreme Court ruling that we got last July, end of June, was so crucial, and it's going to start to be applied. This is where FPC's lawsuit is going into play. All of these things that are tying together, it's making one big case. It's not just the individual of Washington, D.C. and paying $4 million. This is important to understand how big this is. But let's get this last quote, because this is where the DOJ attorney tears apart the gun control rule by the own DOJ attorney. Check this out. Here comes the demolition of the gun control rule. Check this out. Reese gave the judge a paper with illustrations taken from the ATF's final rule, outlining what it does and does not count or consider to be a receiver. To qualify as a regulated receiver, talking about under the ghost gun regulation rule, Reese explained the part must come with a jig or a template, typically a piece of plastic that snaps into place to guide the purchaser on where and how deep to drill the holes. Drill bits and instructions making the receiver readily convertible within minutes to be a fully functioning firearm. And that right there is literally coming from the ATF's website. A DOJ lawyer is citing it in court in Texas, and at the exact same time, you have a Washington, D.C. Superior Court saying, no, those parts are firearms. You can't prove that they're firearms, but I've decided that they are, legislating from the bench. At the exact same time, you have Firearms Policy Coalition putting forward a lawsuit against the ATF, citing that the rule is unconstitutional per the Gun Control Act of 1968. And this is setting up for another Supreme Court fight because it's going to keep going up the system. You can't have inconsistencies, one in Washington, D.C., one in Texas. You have to have a consistent rule of law across the board. Particularly when you get into the whole thing about the federal government saying that it's perfectly fine to discriminate against anyone. We've done it in the 17th and 18th centuries against Catholics, and then we prohibited firearms from Indians based on their race. Biden administration actually did that. Check the other video. I'm telling you, everything's linked. This is starting to become a fight, and you are part of that, and that is why I wanted to bring it to you and zoom out a little bit and look at the whole thing. Let me know what you guys think in the comments field below, and I will see you tonight at the 9 p.m. segment. I'm Braden. See you later.